Okay, so where I was going to cover to start with is a little bit of the legal framework, because that's where a lot of the rights come from, as far as what both federal and state government have said about this issue of what schools need to do as far as university proceedings. So what laws govern this area? The big one is Title IX. That's the one that's mentioned all the time. You see it mostly in the press. It's an older statute, and it's pretty simple. It really just forbids sex discrimination. So the statute itself is pretty short. It doesn't specifically say anything about sexual assault or sexual harassment, but it provides against sex discrimination. So where the specific requirements in this area really come from are from guidance documents. And so guidance documents aren't law. They are guidance in that a federal agency has basically said this is how we interpret the law. In these guidance documents, OCR, the Department of Education Office of Civil Rights, has laid out specific things that universities need to do in this area. The big one, so in 2001, there was a Dear Colleague letter where they said that sexual harassment is a form of sex discrimination, so you need to address sexual harassment as part of Title IX. In 2011, the Dear Colleague letter said that sexual violence is sexual harassment and therefore covered under Title IX, and had some very specific requirements of how universities need to address it. And then there were some additional Dear Colleague letters that came out in 2013. 2015, there's been several different guidance documents. The importance of the fact that it's not law is that it can change quite easily. Through a pen, pretty much. The administration can change it, and that happens. So for example, under the Bush administration, in regards to Title IX and athletics, they put out a guidance document that made it easier for schools to be able to meet one of the three prongs in determining whether there was in athletics. And then the Obama administration withdrew that guidance document. The Obama administration put out guidance regarding to transgender students, and the Trump administration retracted that. So it's unclear exactly what the future of some of these guidance documents are, if they will remain the same, or if the new administration will get rid of them, or issue new guidance that has some additional requirements. And what those are, who knows. But it's important to note this is kind of an ever-changing area, because it is pretty easy to change in regards to what actually Title IX says, because most of it in this area comes from guidance versus law. So what are some of the rights provided under Title IX guidance documents under Title IX? One of the big ones, and the main obligation, is that if a school knows or reasonably should know about harassment, it needs to take steps to end the harassment, prevent its reoccurrence, and remedy its effects. And so that's its broad obligation. That can involve discipline or an investigative process, but maybe not. It really is broader than that. It's looking at broad remedies like training, education, prevention work. All of that kind of fits within those Title IX aspects. Title IX also sets up certain employees that they call responsible employees. What that really means is they are mandatory reporters. In that when a responsible employee becomes aware of sexual misconduct, the university now is aware, and then its obligations to act kick in. So Title IX requires that a responsible employee knows it needs to report to the Title IX coordinator. Title IX doesn't dictate, here are the job positions that are responsible employees. Instead, it defines what they are, and then schools need to determine who fits that definition. Some schools have been really broad with this. Some schools will say, if you're an employee, you're a responsible employee. So they make all employees mandatory reporters. We haven't gone that broadly. We don't believe that every employee fits the definition provided by Title IX as a responsible employee, so we've delineated certain employees as ones that are mandatory reporters. All employees outside of counseling or student health are expected and encouraged to report, but they are deemed to be the responsible employees under Title IX. The other requirement of Title IX is that this university needs to meet the preponderance of the evidence standard when these all these cases. And we're going to talk more about what that means and what that, how that compares to different burdens of proof in a little bit. Title IX also requires that the school put in place certain protective measures, and that can be reasonable changes to housing or class schedule or a job or some kind of extracurricular activity if they're reasonably available. And And that's regardless of whether or not any investigation the school has done or reporting to law enforcement. A school can't retaliate against anyone who makes a report, and they need to prohibit other students from also retaliating against others and address it if it's reported that there is retaliation. And schools need to promptly investigate allegations regardless of whether or not it's reported to the police. And schools cannot use mediation to resolve sexual assault complaints. So can use it for non-sexual assault complaints, but if it's involving sexual assault, they cannot mediate those. And as I said, investigations need to be prompt. And so Title IX says, what does prompt mean? And they say generally that's going to mean about 60 days. So it needs to be resolved in 60 days. If it's not, there needs to be a really good reason of why not. Or you could be violating Title IX that takes much longer than that. And your complaint resolution process needs to be equitable. And what that really means is you need to treat both parties the same. So if you give something to one party or an opportunity to one party, it also needs to be provided to the other. So you can't say this party gets to have an advisor and this party doesn't. This party gets to speak in this way at the hearing and this party doesn't. You need to make sure everything is equal in what opportunities you are providing. And then Title IX also says that if a student requests confidentiality or requests that no investigation be pursued, the school needs to make every effort to respect that. And they kind of talk about this in the terms of you need to give great weight to that request, not to move forward with an investigation. At the same time, Title IX says that you do have an obligation to the entire community to make sure that it's safe and non-discriminatory, and so you're going to have to weigh those two. And Title IX provides some factors that schools can look at when they're making those determinations. And so we've incorporated those into our policy. So when a student says, I don't want anything to be done, I don't want this to be investigated, we'll look at those factors, giving great deference to how a complainant wants to resolve it, but knowing that we sometimes do have to proceed given our other obligation to the entire community. So Title IX also requires that grievance procedures be prompt and equitable, as I said, but then they have a lot of specific requirements about what needs to be in the grievance procedures. And I'm not going to go through them all, just kind of note that there's a lot. And what that means is it's going to make the policy fairly long, which is great in some ways. It's great because everything's in there. So there's a lot of information in the policy, so if somebody's interested in how the school processes it or handles it, they can go to the policy and hopefully will be able to get that answer. The downside is the policy is really long, and that can be difficult for people to be able to read it all and understand it. So a lot of our training is trying to boil down this long policy into something that's more understood.
So this is not all?
No, there's even more that you have to address in the policy. Because there's other laws, and I'm going to talk about some other laws. So Title IX is the one that gets most focus, but it is not the only law that's really impacting this area and how schools respond. So the other big player is Clery. Clery's also been around for a long time, but in its broad form, it's basically statistical. Schools need to provide statistics. They need to have, there's lots of different requirements. It's not just about sexual assault. And it's only about sexual assault, stalking, and dating violence. So sexual harassment wouldn't be covered under Clery, but the sexual assault, dating violence, and stalking would be. And then it also includes a lot of other crimes. And Clery has statistics, but now it has more impact too in what the policy says and some of the requirements of how universities respond. And that's through what's kind of known as the Campus Save Act, which it was part of the reauthorization of the Violence Against Women's Act, and it amended Clery. And so it has some additional requirements that I will go over. And then Virginia state law has gotten involved in 2015 to pass some additional laws in this area. One requiring when we report to law enforcement, and another about transcript notations, when we need to make transcript notations. And then the other kind of law that overlays is FERPA. And that's not any way related to necessarily specifically sexual assault or sexual harassment, but it matters because it's about how information gets shared. The university cannot share information except for very limited circumstances. Some of those exceptions are through Title IX and Clery. So Clery provides some exceptions for when we can share information with parties, so they have information, but outside of individuals, we won't necessarily share with. So the Clery requirements. Clery now requires that both parties have the right to an advisor of choice, and that can be anyone. So it can be an attorney, it can be an advocate, it can be a friend, really it's not limited in any way. That Clery does not require schools to provide an advisor of choice. It just says they are allowed to have one. It also does not dictate what role those advisors need to have, so schools can determine what role the advisor can play. So what we've done is students are provided with hearing advisors, which are university-trained student advisors, and then they can also have an advisor of choice. But none of the advisors can talk for the student in the investigation or the hearing process. They can be present. They can ask for a recess to consult with their advisee. They can help the student drafting questions and writing statements and reviewing the report, but they can't speak in the hearing or they can't directly question anyone in the hearing process. And partly that's to try to keep it as fair as possible. If one side has an attorney and the other side doesn't, we want to make sure that both parties are treated the same in what they're, so one doesn't feel like they're not having the same opportunities as the other in the hearing. They both still have to speak. They don't get to have somebody speak. Clery also requires that campus proceedings be fair and impartial, and this overlaps with Title IX. And the important aspect of this is law. So this is not likely to be very easily changed. It's not as easily changed as the Title IX guidance. It would have to actually be amended along the process. So this will likely stay even as some of those guidance documents are walked back. It also requires that campus proceedings need to be adjudicated by officials who receive annual training on that. It requires that parties receive notification of any delays, the outcome of the disciplinary proceedings, the opportunity to appeal when the results are final, and the reason for the results and the sanction. It also requires that schools issue protective measures. So again, that's another overlap with Title IX that is now codified in Clery, where if changes in housing, changes in class schedule, if they're reasonably available and the complainant requests it, we need to provide it regardless of whether or not they choose to report to the police. And they have the right to be assisted by campus authorities in notifying law enforcement. So if somebody goes to public safety and says they want to make a police report, public safety will assist that person in contacting law enforcement and get them to help them make a police report. And then when a complainant reports to the university, under Clery, the complainant needs to receive a written notification of rights and options. And so when I meet with a complainant, I always will provide a sheet of written information for them. And that's provided by Clery. So state law. This is kind of an outline of what happens under state law, whether or not the university will report to law enforcement with personally identifiable information. And so the state law requires that universities have a review committee that's made up of at least 3 individuals, and it has to include someone from public safety, someone from student affairs, and the Title IX coordinator. And they need to review all reports, and then they need to determine whether or not disclosure is necessary to protect the health or safety of the student or another individual. And if yes, they will disclose to law enforcement with personally identifiable information. If no, they do not disclose with personally identifiable information, but they may need to disclose to the Commonwealth that a report has been made if it was unfettered. So it kind of looks more complicated on here, but the main thing is disclosure necessary to protect the health and safety? So I think sometimes when this law was passed, there's a lot of information that every report now needs to be reported to law enforcement. That's not true. It is only going to be cases where certain factors are met. We have listed the factors in the policy. It's mostly dealing where there's been prior reports, or if there was force or drugs used, if there was multiple perpetrators. So a lot of different types of factors that we would look at. Okay, and I'm going to talk about our process. So our policy incorporates those legal aspects of rights. And so those are provided to any of the parties going through the system. And what that looks like when a report comes in, I'll kind of walk through. So when we receive a report, I'll try to meet with the complainant if we know the complainant, and discuss the availability of supportive and protective measures, change in housing, change in class schedule, change in work schedule, and then talk through what the resolution options are, and then see how the complainant wants to respond. If the complainant wants to proceed with the investigation and disciplinary process, we'll do so in every case. So that is always up to the complainant. If the complainant wants to proceed with an investigation, they will. I should say, right now I'm focusing on complaints against other students. There's a separate but very similar process for complaints against employees. If a complainant says they don't want to proceed with an investigation, that's when we do that weighing required by Title. So we will look at the factors in the policy to determine whether or not that request can be granted or whether or not we need to proceed with an investigation regardless. If we do need to decide, we do need to proceed with an investigation, we'll start with that process, but the complainant would be notified and does not need to participate. And if we do believe we can grant that, and again, in most circumstances, we're going to grant that because we give great weight to how the complainant wants to proceed, we're going to be discussing what remedies. We still want to provide remedies, and we can provide a lot of remedies, even remaining, someone wants to remain confidential or not proceeding with an investigation. So maybe a change in class schedule or academic adjustments, change in housing, change in work schedule, maybe broader training. We need to retarget some of our training or do some more specific targeted training on a certain area. A no contact directive is a non-disciplinary measure, so sometimes people don't want to proceed with an investigation, but they would like a no contact directive. We can issue that as part of remedies in case resolution. If we're going through the investigative process, the first step is respondents notified of the report. There's a meeting with the respondent to discuss procedure and process. Advisors are provided, so the names of HAs are provided to the parties, and then they can have an advisor of choice. And then there's an investigation with investigators who will speak to the parties, speak to any witnesses, gather the information. Parties can suggest who they want someone to talk to, for the investigators to talk to. They can provide evidence. And then the investigators put together a report. And the investigators are neutral fact finders. They do not make a determination in the case. So they are just gathering information, and they put that into a report, and then review that report with the parties. And the parties can comment on it, ask for additional investigation, ask that changes be made, and it's designed to be pretty collaborative in trying to make sure that the report incorporates both parties' arguments. And then that's submitted to the chair of the Harassment and Sexual Misconduct Board, and the chair determines whether a charge should be issued. If not, the case is closed. If so, then the parties have another opportunity to review the report. They then have a pre-hearing conference where they discuss whether they want redactions to certain evidence, whether they want to make changes to the report, which witnesses they want to call at the hearing. And then there's a hearing. There's a panel of 3 administrators who will question the parties if they're present. The parties can question each other by submitting written questions that is asked by the chair. And then if there's witnesses, the same thing is done. Parties can give a statement to the hearing panel. And then the hearing panel determines whether or not the policy was violated by a preponderance of the evidence. And if so, we'll issue a sanction. And then the case can be appealed on limited grounds. So if there's a procedural error defect, new evidence, extraordinary circumstances, or disproportionate sanction, it will all be grounds that somebody can. So talking about the burden of proof. The burden of proof is preponderance of the evidence. And that means more likely than not. So if the hearing panel believes that it is more likely than not that the alleged misconduct occurred, the finding should be responsible. I like this pyramid because it kind of shows all the different burdens of proof that are commonly used and where it falls. So the criminal justice process uses beyond a reasonable doubt, which is the highest burden of proof that is used. And that means if you have any reasonable doubt, not all, any doubt, but any reasonable doubt, you should find not guilty. The preponderance of the evidence is the civil standard, which would be used in civil court. It is important to note that the standard is not it could have happened. So the respondent is presumed to be not responsible. And it is only when the panel finds that burden of proof has been met that the respondent will be found responsible. And so if the panel says, okay, it could have happened, but it's 50-50, and I just can't get enough to get over that edge, the result should be not responsible. It does not mean innocent. It's a finding of not responsible. So it doesn't mean it didn't happen. It just means the burden of proof wasn't met. And some questions I get, or I've gotten in the past, is, well, would it be possible for someone to be found, if somebody was maybe going through the criminal justice process and they were found not guilty and then they were found responsible in the university process, how would that happen? And this is how it could happen. There's different burdens of proof. So if somebody went through the criminal justice process and was found not guilty, that's not a finding the person is innocent. It's a finding that the burden of proof, which is very, very high, was not met in that case. But just because the burden of proof of beyond a reasonable doubt wasn't met doesn't mean that one of those lower burdens of proof wasn't met, because the evidence might be enough to reach them. That makes sense. It's common. It also happens, in cases where somebody might be found not guilty for a criminal violation and sue civilly in civil court and be found liable. And it's the same kind of thing. While I'm here and kind of mentioning the criminal justice process, I do think it's important to distinguish the difference between our process and the criminal justice process, because we are not the criminal justice system. We are not determining whether or not a crime has occurred. So when the hearing panel finds responsible, it is responsible for a policy violation of university policy. And I think sometimes that gets a little bit confused in that it almost seems like sometimes the public discourse at least seems to conflate the two, where it almost seems like it's setting up the university as some kind of substitute for the criminal justice process, and we are not. We are in no way determining whether or not a crime occurred, and sometimes the law in Virginia differs from what our policy says. For example, stalking. We use the federal definition of stalking in our policy. Virginia law is different. Virginia law is much more narrow in what constitutes than what our policy would be. So we don't even have necessarily the same language as Virginia law. It's different procedure, different process. Any questions about that? I think there always tends to be a lot of questions about
I know that Virginia doesn't have a statute of limitations for sexual assault. Does the school have any sort of statute of limitations on policy violations?
No, it doesn't. So our policy specifically says that there is not really any time frame for bringing things forward. Logistically, there may be some time frames, meaning one, the longer before something's brought forward, the less evidence there may be to be able to conduct the investigation. So it is oftentimes harder to investigate, just by the fact that witnesses may not remember as clearly something that happened 2 years ago than something that was more recent in memory. The other aspect too is if somebody has graduated, we no longer have disciplinary authority over that person. So we would not proceed with this process. Now that doesn't mean we still might not address it. So if somebody brings forward a report against somebody who has graduated, we could go through the non-student process, and one of the remedies could be trespassing that person or something like that. But we don't have any disciplinary authority again, because we are not the criminal justice system. So it only applies we only have authority for students, if that makes sense. But other than that, there's not any set. If someone comes forward, I don't ever say, I'm sorry, you can't bring this. It's been too long.
Do state regulations apply to public university? Like, do they have to adhere, or can they create their own as well on top, like, for their own policy?
You mean the state law? That's
Is state law like Virginia Tech? Can Virginia Tech create their own policy on top of what the state requires, or can they go off of the federal as well?
So state schools they don't have to follow the criminal code. Is that what you mean? Yeah. They can create their own definitions and their own policies.
Right.
Regards to what state law says, because again, the state law for determining what's a crime doesn't really have any impact on what
because this is all school policy.
Right. As far as how, the government can act and say schools need to follow this, and they would be more likely to do it if it's a state.
Well, I guess that's what I was asking really, and sorry, it's kind of off topic, but if the state defines its public schools policies.
And it could. There are states that have done that. California is one which specifically said that institutions need to use a certain definition of consent. And so it can. Virginia hasn't done that yet as far as what needs to be prohibited or not, but they could.
Yeah.
And they could, I know that the state reporting law and the transcript notation bill apply to private institutions as well as public. So we operate within the state. The other question is going to ask, what about false reporting? And so we address that in the policy. And somebody makes a report that's intentionally false or made maliciously without regard to truth, they could face disciplinary action under the honor system. But that does not mean it does not apply if the report is made in good faith, even if the facts alleged are not later substantiated by an investigation. It's when something is made intentionally false or with malice. But it is prohibited by policy and can be punished under the Any questions generally about policy, things you were wondering about? Yeah.
Do you know a percentage, or do you know like how many cases have been false reports at all? in the last couple of years?
Yeah, and I don't, yeah, no.
Based on the anonymous data that we get, what percentage would you say of students that report go to investigation?
Oh, for the report. Well, so, very few. So the vast majority of reports do not proceed with an investigation and disciplinary process. Most reports that are received are processed through some form of remedies-based resolution, and that is due to the request of the complainant. Because like I said, if somebody wants to move forward with an investigation, we will always do that. But if the complainant requests not to, generally we're going to respect that unless certain factors are met. And the vast majority are not. They request not to move forward with an investigation.
What happens if it's something between two institutions, like two colleges?
So, yeah, so that could happen particularly here with VMI. And it depends on who is the respondent. So let's say the respondent is somebody from VMI or from another institution. We can notify that institution of the complaint and they can proceed with their disciplinary process and procedure against that student. If there is a student reporting against a W&L student, we can proceed with our investigative process against that student, even if the complainant is not a student.
Okay.
So it really, depending on where jurisdiction lies, will really depend on the identity of the respondent.
So does that mean the duty prescribed to schools is both they have to protect a student as well as kind of penalize another student?
They need to investigate it and process it, and then most schools have set up when they would handle it if it's against a student or not.
Okay.
But yes, I mean,
Like would VMI be looking out for the student? Like say there's a student at WNL who's the defendant for, sorry,
was the complainant.
the complainant. VMI be looking after that student or would WNL?
We would provide remedies. So again, we could both be reported to. We wouldn't necessarily proceed with a disciplinary action, but we would provide remedies to the student. And that's regardless of who the respondent is. So the complainant could report to the institution. It could be a community member who we don't really have any connection with. And if it's a local community member, we can trespass, and we've done that. So we'll trespass them from campus, but that's about the extent that we can do against that person. But we can definitely provide remedies to the complainant and work towards remedies.
Thank you so much.
Okay, well, mentioned data. I'm going to do a plug, so it just went out. Sexual misconduct survey. Encourage everyone to take it. We do want to get good data about what is happening on campus, and the more students that take the survey, the better the data will be. So I encourage you to do that. You should receive an email about it. You'll get lots of reminders, I'm sure.